Okay, great. So welcome, everybody. This is the Labor Subcommittee of the Government, Labor, and Elections Committee. We have 4 bills today. These bills are for discussion only at this point. We are not voting on anything at this session. Some of these bills have amendments, and we are going to start with HB 45, which is HB 45, Labor and Employment, Mandatory Meetings on Religious or Political Matters, Employee Attendance and Participation, Maryland Worker Freedom Act. And there is one amendment that just came in. Kyra, did you have a chance to look at that yet?
Yes, I did.
Can you talk about what that does, or is that what we were thinking it was?
Um, Give me 1 second. Well, I can explain what the bill does first before the amendments and then
That
explain the amendments if that's okay.
that would be perfect. Thank you.
Okay, perfect. Let's get to it. Okay. HB 45 prohibits employers and their agents, representatives, or designees from taking or threatening to take certain adverse actions against an employee or applicant for employment because the employee or applicant declines to attend or participate in employer-sponsored meetings during which the employer communicates the opinion of the employer regarding religious or political matters. Additionally, the bill authorizes an employee to file a certain complaint with the Commissioner of Labor and Industry. And it looks like there is an amendment to this bill. Amendment number 1 is, well, the amendments are technical.
So I don't have the amendment in front of me. Let me, is the amendment adding applicants?
Yes, it's a technical addition of or applicant for employment. So the effect that has is authorizing an employee or applicant for employment to file a certain complaint with the Commissioner of Labor and Industry.
And so this was just added to address an issue that the fiscal note analyst found a mistake in the bill. So any discussion about the, I guess, about the bill?
There
Delegate
is a hand raised.
Tarasa.
Oh, Madam Chair, I just didn't know. First of all, is it possible if we have an amendment? I don't think this one's very complicated, but to put it on the screen so everybody can see what we're talking about. And the other, I don't know. I think this is a good bill. I think it's a needed bill. But I don't know if I have a question about the amendment. It's just technical. It's not adding something that wasn't already in the bill.
So the bill allows for, as it was originally written, the bill allowed for an employee to file a complaint. But the bill text also prohibits the employer from discriminating against applicants. But because applicants weren't included in that remedy provision, they had no remedy to file a
Oh, so
complaint
it
under
just,
the bill.
oh, sorry to interrupt. Sorry. So it just added them into the remedy portion.
That's correct.
I think that amendment makes sense, and I think it's an important bill.
All right, any other discussion?
It looks like Delegate Ciliberti has a question.
Delegate Ciliberti.
Yes, Madam Chair. I have been around the block quite a bit, but it comes to my mind that this is not a new bill or a new problem. It's been around quite a long time, and I thought it was solved.
Well,
Go ahead.
thank you. Thank you so much, Delegate. You are correct that we have seen this before. This bill passed the House last year in 2025. It did not pass the Senate, which is why we are taking it up again. I will say that the bill sponsor made some changes that would tighten up the bill and address some of the concerns that were raised last year. So it is a tighter bill that addresses some of the current concerns that were raised.
Okey doke.
Any other discussion?
I move the bill.
Well, thank you so much, Delia. We're not going to actually be voting on the bill
sorry.
tonight. That's okay. I really appreciate your your willingness to move forward on that, and we will need to address the amendments first when we get to that point. But we're not voting tonight. So any other comments, thoughts, or questions about that bill?
I just wanted to say happy birthday to Delegate Ciliberti again.
I'm leaving.
All right. Well, then I guess with that, let's move on to the next one. So the next bill is HB sorry. I am so sorry. I apologize here.
1108.
Yeah, HB 1108. Thank you. HB 1108, which is labor and employment, greenhouse workers, collective bargaining, and heat protection. Kyra, do you want to talk about what the bill does?
HB 1108 establishes collective bargaining rights for greenhouse employees. It requires the Secretary of Labor to adopt regulations and authorizes the Secretary to investigate and enforce an alleged violation. Additionally, each employer who operates a controlled environment agricultural operation must provide employees with paid rest breaks of at least 5 minutes for each hour that the heat index inside a controlled agricultural operation reaches and maintains at least 90 degrees Fahrenheit. And there are amendments to this bill. Give me 1 second. Okay, so amendment number 1 is technical. Amendment number 2 alters the oversight authority for the collective bargaining piece. For the collective bargaining piece from the Secretary of Labor to the Maryland Public Employee Relations Board. And then it clarifies that an employee under the bill does not include an agricultural retail employee.
Okay, thank you so much. And since the bill sponsor is a member of this subcommittee, would the bill sponsor like to discuss the amendments?
Sure, I'd love to, Madam Chair. Thank you for that opportunity. So, yeah, the amendments are very simple. So the first thing is as we alluded to in the hearing, we took out the retail side of this formulation from collective bargaining. While I believe that every worker deserves collective bargaining rights, we just thought that it was cleaner, given the fact that we're trying to make the point here that these greenhouse workers are virtually completely analogous to workers that are in warehouses, for example, that are protected by the National Labor Relations Act. We took out the retail side because they're not actually the ones who are sort of working in the greenhouse side and being subject to the high heat and et cetera. So that was that amendment, essentially just a bit of a concession amendment. And then the second one is a fiscal note amendment, which puts the administration of this regime under the board's authority instead of the Department of Labor. That's to address the fiscal note, which was something like $200,000 to $300,000. With this amendment, it essentially removes the fiscal note, but the Department of Labor still has the ability to enforce the workplace heat standards because they already do that under existing law. So we've gotten with the amendment, we've gotten the fiscal note down to a very manageable size.
And you are working on getting that in writing about the revised fiscal note.
Yes.
Great. Thank you. Delegate Tarasa.
Thank you, Madam Chair. Could the sponsor just say once more, what did it moved it from what to what?
So are you talking about the amendment?
The last piece you said, yeah.
So under the bill as it came in, it was like basically like the responsibility for doing the entirety of the bill, including sort of the collective bargaining piece and the heat standards, were all under the Department of Labor. And so they basically said that like that would be like they'd have to like get several new pins. And instead we moved the collective bargaining portion to the Maryland Public Employee Relations Board.
Oh, okay.
Already does all this. And we kept the heat standard thing with the Department of Labor. And that's because in conversations with the chair of the board, he has told us that with existing resources, they can carry out the collective bargaining portion of the bill.
Okay, great. And then Madam Chair, can I ask another question
Sure.
about, oh geez, now I forgot. Oh, taking out the retail side, is that what we said? I'm sorry, I'm a little foggy. I don't feel great today.
It's okay.
But taking out the retail side, how would you, like, are they exempted if they're on the retail side? Because I could envision a somewhere where they do both.
Yeah, so this came up in the hearing. In fact, you may have been the person who raised this question, Dr. Taraz. I can't remember.
Maybe. I can't remember either.
Yeah, but when you have like a Home Depot situation where you have like a greenhouse, but then you also
right.
have a retail side, the retail side workers are already not agricultural workers under the National Labor Relations Act. So that's
I
why
got
we're
it.
taking them out. We're mostly viewing, viewing this and arguably because of that, the greenhouse workers in the Home Depot are also not exempted by the National Labor Relations Act. This is focused on standalone greenhouses, without the retail component, and
Okay,
that's why we took the retail workers out.
So standalone where they're not, because I understand why it's different at like a Home Depot or Lowe's. Not that I don't think those folks should be able to organize, but that's just a separate question.
Sure.
I understand why it's distinguishable, but if you're working at a greenhouse on a farm, and maybe there's also like a roadside thing that's right there, like people can come up and you're doing both. I wouldn't want to exclude those folks who are primarily greenhouse workers. So I don't know if there's like a percent thing or something, but
Yeah, that's a good point. Kyra, could you pull up the amendment and also, if I could, Madam Chair, call on Trent? He probably can illuminate more. Mr. Learman can probably illuminate more on this
Sure.
point.
So if I could just interrupt, my Assistant Charles has the amendments ready. If you'd like, he can share a screen, Kyra.
I would love that.
I would too.
Okay, Charles, go ahead.
Yes, please. I was trying to get my mic on.
One moment, I am trying to share it. Apologies. Okay.
Yay.
Okay, so
Okay,
yeah,
well,
so
That's actually the amendment. Do you have the reprint?
Yes, let me see.
yeah. But and I have it up too, and I think I can probably very quickly answer Delegate Terraz's question, which is that the definition here, in the amendment, it says employee, in other words, an employee who gets collective bargaining rights under the bill. Employee does not include an individual whose job duties exclusively involve the provision of retail services. So that gets to the percentage point the Delegate Terraza raised. So only if you are exclusively a retail worker and you never work in the greenhouse are you now, per this amendment, removed from the bill's provisions.
Okay, and that makes a lot of sense to me, but if they're not greenhouse workers, why do we have to call them out as not being part
Just
of?
mostly just kind of belt and suspenders.
Neither are dental assistants or,
Yeah, mostly just for clarity, statutory clarity.
Okay. I can live with it. Thank you.
All right, do you still need to see the reprint?
Generally speaking, I think it's helpful, but I don't necessarily need to see it right now, no. But I mean, I think it's helpful to have it up if we're discussing.
Okay, Delegate Ciliberti?
Yes, help me out here. What is the alternative to collective bargaining? Because it's late in the afternoon and I should know that, but I don't.
I'm sorry. Do you mind asking that question again?
Certainly. What is the alternative to collective bargaining? If you don't have that, how else do we bargain?
I don't believe it's my understanding that if you don't have collective bargaining rights, then you don't have the right to bargain at all.
Really?
Yes.
But would the bill sponsor want to address that at all?
Yeah, sure. I actually think, as always, Delegate Ciliberti asks a very insightful question that's kind of like kind of a core opportunity here to talk through these issues as this newly formed labor subcommittee. But essentially, the alternative to collective bargaining rights means that basically workers have to have a voice or try to influence workplace conditions without being able to bargain collectively. And so generally that means that you just kind of have individual employment contracts. So instead of being able to negotiate as a group, each worker would have to negotiate their own pay and benefits and working conditions directly with the employer. So it'd be, one-on-one negotiations essentially, as opposed to being able to band together and have strength in numbers with your coworkers to be able to bargain as a unit. And so, unfortunately, one of the downsides of not having collective bargaining rights means you also don't have protections that are sacrosanct and inextricably linked with those bargaining rights, which means that if you try to form a union, collectively organize, bring other coworkers with you to try to put pressure on your employer at the same time, you can face retaliation. And as we heard during the hearing, unfortunately, one or two of the workers at one of these greenhouses in Maryland actually was fired for essentially trying to bargain collectively. So the alternative to collective bargaining is essentially individual bargaining, but individual bargaining doesn't really work if you can get fired for trying to speak your mind.
Yeah, good point. Did that answer your question, Delegate Soliberti?
Well, to assume that if you bargain individually, you're liable to lose your job, I think that's a stretch. But we'll let it go at this point.
I don't know that it is a stretch if it's actually happened to some of the people who came to testify.
Oh, I'm
Is
sure it
that
has
correct,
happened.
Delegates?
Yes.
I mean,
I'm
it
sure.
depends. I'm sorry, Delegate, go ahead.
No, I didn't mean to interrupt you.
No, I interrupted you.
I'm sure it has happened, but to the extent that we're pushing it, I'm not quite sure it's that big. However, I'm just guessing. Let's continue.
Okay, thank you so much. Any other discussion on this bill or the amendments? Okay. All right, we ready to move on then?
Yep.
Okay, great. We are rolling along. So the next bill is HB. Charles, what's the next bill?
1241.
Yes, the next bill is 12.
Bereavement.
Right.
There is 1241 bereavement leave qualified relationships. And still to do is HB 1070 Department of Social and Economic Mobility Workforce Opportunities Grant Program and Fund.
Okay, well, let's start with 1241. Kyra, do you want to talk about what the bill does?
Of course. HB 1241 alters categories of individuals whose death would allow an employee to use leave with pay for bereavement. Under the bill, bereavement leave would be allowed to be used on the death of an individual the employee had a qualified relationship with, including an immediate family member, grandparent, sibling, domestic partner, step relation, adopted relation, foster relation, and de facto relation. There is one amendment to the bill. Amendment number 1 is technical. Amendment number 2 adds any other blood relation of the employee or the employee's spouse to the list of qualified relationship. And amendment number 3 allows an employee to use leave with pay or unpaid leave for bereavement.
Okay, great. All right, any questions or discussion on that? Delegate Tarasa?
Thank you, Madam Chair. I think this makes a lot of sense. To be honest, I was surprised at some of the relationships that didn't count. I don't know how you would, I don't know how like a step relationship or a foster relationship, I just don't even understand how those could not count. I mean, if you had a foster child, unfortunately died, like I can't imagine how we could not honor that in our bereavement leave policies. So I agree with this bill.
And I will also point out that this bill does not create any new leave categories. All it does is it allows employees to use leave that they already have, an immediate relation, but who may have, a relationship with them such that they are grieving. So it's really just allowing them to use leave that they already have. Oh, great. Okay, so we have the reprint up there. Do you want to scroll down a little bit? Keep going, keep going, keep going. Okay, so here's the first amendment. Yep, too far. So right there to the list of people that you're allowed to use the leave for, it adds any other blood relation of the employee or of the employee's spouse. So go down a little bit. Right there. And so this one adds the ability to use unpaid leave if the employee does not have earned leave available. Keep going. All right, I think that's it then. Is that it, Kyra?
That's it.
Great. All right, any questions, Delegate Tarasa?
Sorry, I think that was up from before.
Okay, Delegate Schindler.
Thank you, Madam Chair. So I did have a question. So the way I understood this bill is it was adding, relations and people that qualify for bereavement leave, but it wasn't changing employers' bereavement leave, bank or what have you. But the extra amendment is a little confusing to me in that case, because when it says if you don't have paid leave, you could take unpaid leave. Is that superseding like employers' leave policy then, or?
Kyra, do you know the answer to that?
I'm not completely sure with the answer to that. It's my understanding, it's my understanding that if under the text of the bill, it doesn't really speak to like a limit on bereavement leave, but I believe that if there are multiple deaths, for example, that maybe fall under this category, it would, I guess, allow an employee to use some sort of other leave. But again, it's not clear based on the bill text.
I only worry, I like this bill, and there are people that should be included that I guess weren't before, like Delegate Tarasa said about the foster kids or foster families, more modernizing of what the family looks like. But I do worry if we open it up in a way that supersedes like the amount of leave people have for bereavement. I can hear the argument to the counter that, people are going to say, oh, my second cousin died or my third cousin died, and you're going to have a string of this. I don't think that should preclude us from moving it, but I'm a little confused about what that amendment seeks to do.
Yeah, I think that's a good question. I think it's the intent is to give an option for people who don't have paid leave, but I do see the concern that could have more operational impact where if somebody is taking paid leave that they've already earned, that's already taken into account in the employer's plans.
Right.
Is somebody here from the sponsor? I don't see anyone from the sponsor here. I mean, we can reach out to the sponsor for clarification for Delegate Stewart.
Yeah, unfortunately, I don't really have the answer. I mean, I think my reading of this, I mean, it says basically you can either take leave without pay, or if you don't have any paid leave available, either because you've used it all or because your employer doesn't offer paid bereavement leave, then you're basically guaranteed unpaid leave. My question is, I guess maybe if we have a reprint, if you could scroll down to that portion of the reprint, it would be helpful.
I'm sorry, Delegate, which portion?
Yeah,
A
yeah,
little
keep
bit more.
going. That just
That's it.
that part, yeah. Right. So employee may use leave without pay for bereavement leave or unpaid leave for bereavement leave. So I guess this is not, the number of days isn't capped. Is that right, Kyra? So it's just kind of like you can get leave.
That's my reading as well. I know with leave with pay, there's still some sort of communication with the employer as to using that leave. And so I'm not really sure. I think that would, because the bill is silent on it, that would kind of leave that in the employer's hands,
Yeah.
whether to honor that request or not.
Okay. Yeah, I mean, we can certainly dig into it more and before the next meeting. I mean, I think, to piggyback off what Delegate Schindler was saying, I mean, I think we probably don't want to create a regime where if you have any of these totally legitimate family categories pass away, that then you can take essentially a limitless unpaid leave, even if it's unpaid. That seems like probably a track that we don't necessarily want to go down, and probably that the sponsor's not intending with this amendment. So I'm sure we can get to the bottom of it.
Yeah, yeah. Even if it's unpaid, it still has the potential to have operational impact. Delegate Teresa, I thought I saw your hand up. Did you have?
The only thing I'd point out about that, and I wasn't sure which Delegate Schindler was referring to, whether it was the adding more relationships or this part, but it sounds like from what Delegate Stewart said, it's both. But it's not. You're saying it's limitless, like per occasion, or is it limitless per occasion, or you're concerned there'll be like unlimited number of claims for bereavement?
Limitless per occasion. I'm not worried about people having to take leave because they've so many different other family members have died or whatever.
Okay.
I don't think people really going to game the system in that way. I just mean if
I
this
got it.
if this
Okay.
is read to be that you can just take an indeterminate amount of unpaid leave,
I see.
even if it only happens once, that can't possibly be the intent of the amendment. But that's how I read it. But I could definitely be wrong. I mean, I know that state workers, I believe, get 3 days of bereavement leave for the death of an immediate family member for state workers. And then I think they can use up to like an additional like 5 days of sick leave or something like that. So,
Okay.
yeah, and I mean, it's weird that this is not tied to a specific number of days, I guess is what I'm saying.
Yeah, Delegate Stewart hit the nail on the head of my worry. I just want to make sure it doesn't open some kind of weird loophole that, we've created like an unlimited leave bank now.
Right. All right. Yeah, we can follow up with the bill sponsor on that and dig into the language a little bit more before the discussion. Questions, comments? All right, great. So we just have one more, and that one more is HB 1070, correct?
Yep.
Which is Stephanie Smith, Department of Social and Economic Mobility Workforce Opportunities Grant Program and Fund.
So HB 1070 establishes the Workforce Opportunities Grant Program, an associated special fund in the Department of Social and Economic Mobility to provide grants to support the planning and execution of workforce events and job fairs in the state that connect job seekers with employers. Subject to the availability of funding, DOSEM must establish an application process to award grants on a competitive basis as specified. There are no amendments to my knowledge.
Any discussion?
Delegate Ruth, hi, this is Morgan from Delegate Smith's office. She just wanted to make sure that the group was aware that we are not accepting amendments from the Maryland workforce, and we would like to move the bill clean as is. And I'm not sure if the group was also aware that Department of Labor was also interested in being included in the bill, and Delegate Smith politely, disagreed, saying that we already have a state agency involved, and the any more would cause potentially any, confusion. So we would like to move the bill clean as is with no amendments.
Thank you. We'll take that into consideration. Thank you. Thank you. So any discussion from subcommittee members? And just to clarify, I should have said this at the top of the meeting. Subcommittee members, if anybody besides subcommittee members who's on here, really should only speak if we call on them. And certainly I want the bill sponsors here. If the bill sponsors are here, we will call on you. But I just wanted to clarify that. So any discussion on this bill? And so I think this is a great bill. I love that it creates an avenue to bring employers and employees together. I do wonder about the appropriation. Kyra, do you know if we have any kind of feedback from appropriations on this, or?
No, I don't have any feedback from appropriations on this bill other than what's included in the fiscal note.
Okay, Morgan, do you have any feedback on that about the $500,000 fiscal note?
No, there was nothing from the Appropriations Committee.
All right.
Wow.
All right. Thank you so much. So, any other discussion on this bill? Delegate Stewart.
Thank you, Madam Chair. Yeah, I think it's a mandatory appropriation. So, I mean, the fiscal note, I think, just is the fiscal note. It's going to cost $500K, so I think probably in order to move it, obviously, we'd have to get appropriations approval, and, maybe they lower it. Maybe they say $500K is okay. I do like the bill. I think this is a good use of $500,000. I mean, this is exactly the kind of thing that we should be doing to make sure we're connecting people with jobs. I also will just say that I'm relieved to hear that the sponsor just wants a clean bill, because I was a little skeptical in the hearing of the Workforce Association bill, or amendment rather, where they wanted people to have to go through them to participate and to get the grants from the state. That seemed a little odd to me. So I'm pleased to hear that Delegate Smith agrees with me on that.
Thank you. Delegate Schindler.
I'd agree. Workforce development is like the number one thing in our area that we're pushing for. We have a lot of blue collar jobs. We don't really, have the capacity. So I think this is a good use of the money if appropriations will allow it.
Great. Well, I believe the bill sponsor is on the Appropriations Committee, so hopefully she is having those conversations and we can get that approval. All right. Well, I think that's it then. Anything else for the good of the order? All right. Well, thank you so much. And that Delegate Solomon and Delegate Solomon and Delegate Chisholm are excused today. So, but we did have quorum. All right. So thank you so much. And I will see you all later.